According to the 2024 Annual Homeless Assessment Report to Congress, on a single night in January, 771,480 people experienced homelessness in the United States, the largest number since data collection began and an overall increase of 19% since 2007. As homeless rates rise, cities across the country have made various attempts to restrict people living in public. This has raised both constitutional and ethical questions. In this project, we will analyze the constitutional limits of power for local governments to restrict people living in public. We will look at this through key court rulings in the 4th, 8th, and 14th Amendments. We will also look at 2 case studies in Burien, Washington, and Portland, Oregon for how local governments have attempted to restrict people living in public, including an interview with Portland Mayor Keith Wilson. The 8th Amendment is the most important and controversial in regards to homelessness. It states, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. Local governments, though, want to keep public spaces clean and safe and usable for everyone, so they often pass rules and laws that ban camping in public areas. But people experiencing homelessness and their advocates argue that these laws can be unfair and cruel. If people have no other place to go, punishing them for sleeping outside is a violation of their 8th Amendment rights. This raises the question, is it cruel and unusual punishment to fine someone or arrest someone for sleeping in public when they have no other option? 2 cases in particular have shaped how we address homelessness: Martin v. City of Boise and Grants Pass v. Johnson. To begin with, let's look at Martin v. City of Boise. The landmark case Martin v. City of Boise challenged the constitutionality of local ordinances that criminalize sleeping outdoors when no alternative shelter was available. The Ninth Circuit Court ruled that prosecuting homeless individuals for sleeping on public property when they had nowhere else to go violated their 8th Amendment's prohibition on cruel and unusual punishment. This decision affirmed that local governments cannot punish people for a condition they cannot control, in this case homelessness, by criminalizing the unavoidable act of sleeping outside without shelter. The ruling set a critical constitutional limit on the power of cities and municipalities, emphasizing that laws must not unjustly target vulnerable populations for survival behaviors. It reinforces the principle that governments must consider the reality of homelessness, ensuring that the enforcement of public ordinances respects the fundamental human rights ensured in the Constitution. However, in 2024, Martin v. City of Boise was overruled by the Supreme Court case Grants Pass v. Johnson. In this landmark case, the City of Grants Pass v. Johnson, the Supreme Court ruled that local governments do not violate the 8th Amendment's cruel and unusual punishment clause when enforcing generally applicable public camping laws against homeless individuals. This overruled the Ninth Circuit Court's previous ruling on the case. The court held that these laws regulate conduct and not status, therefore do not criminalize homelessness itself. This decision reverses the Ninth Circuit Court's earlier injunction that barred enforcement of such laws whenever shelter beds were unavailable. The ruling clarifies that the 8th Amendment limits apply to the type of punishment imposed after conviction, not to the criminalization of a certain behavior related to homelessness. As a result, local governments retain broad constitutional authority to address public health and safety concerns associated with people living in public spaces, allowing them to enforce regulations on camping, sleeping, and related activities without fear of judicial overreach. This decision reinforces federalism by affirming that policy decisions on homelessness are primarily a matter of elected officials and not federal judges. However, this ruling has been highly controversial, as many say it still violates the 8th Amendment. Ruth Bernstein, a legal director for the ACLU of Alaska, said, and I quote, "Today's ruling was a bleak and cruel decision that will allow cities to punish people who are just trying to survive while living unhoused." To summarize, following the overruling of Martin v. City of Boise by Grants Pass v. Johnson, they established under the 8th Amendment, local governments can enforce public camping bans, ticket and remove people regardless of shelter availability. However, they still must enforce these laws fairly. Next, we're going to look at the 14th Amendment. The 14th Amendment reads, "No state shall make or enforce any law which shall abridge the privileges or immunities as citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. This case has sparked a debate regarding homelessness. Do local laws that ban living, sleeping, or camping in public violate a person's right to fair and equal treatment under the 14th Amendment? The landmark case Lavin v. City of Los Angeles significantly reinforced the constitutional limits on local governments under the 14th Amendment's Due Process Clause. In this case, the court ruled that homeless individuals possess a protected property interest in their unabandoned personal belongings, even when temporarily left unattended in public sidewalks. The City of Los Angeles had been seizing and immediately destroying these possessions without providing any notice or opportunity to be heard, a practice that the court found to be in violation of the due process right. This ruling underscores that local governments must respect procedural due process before depriving individuals of their property, regardless of the challenges posed by homelessness in public spaces. It establishes a clear constitutional boundary. While cities have a duty to maintain public health and safety, they cannot circumvent fundamental rights by confiscating and destroying personal effects of vulnerable populations. This decision ensures that the power of local authorities to address issues related to people living in public remains subject to the protections guaranteed by the 14th Amendment. Next, we're going to look at the Pottinger v. City of Miami case, which challenged the city's unconstitutional practice of arresting homeless individuals for harmless, involuntary acts essential to survival, such as sleeping or eating in public spaces. The federal court ruled that these arrests violated the constitutional rights of homeless people under 42 U.S.C. 1983, emphasizing that local governments cannot criminalize homelessness or the necessity of life-sustaining activities that come with it. The court enjoined the city from arresting homeless individuals for such conduct and mandated the creation of arrest-free zones and strict protocols restricting the city's rights. This landmark ruling underscores the constitutional limits on local governments, affirming that public authorities cannot use their power to punish people simply for being homeless or engaging in unavoidable public behavior, protecting civil liberties against unjust municipal policies. These two landmark cases lay out the framework for what governments can and cannot do underneath the 14th Amendment to restrict people living in public. They establish that they still can pass laws that limit when and where people can live in public, or camp in public spaces, and clear encampments and take property from public spaces, as long as they follow proper procedures. However, cities cannot discriminate based on housing status, or confiscate or destroy property without due process. One way local governments have attempted to restrict people living in public is by confiscating their tents and belongings in encampments, forcing them to move. Some have argued that this violates their Fourth Amendment right. The Fourth Amendment states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued but upon probable cause." This has raised the question, can cities legally take or destroy homeless people's belongings during sweeps or enforcement actions without violating the Fourth Amendment's protection against unreasonable seizures? The case of Lavin v. City of Los Angeles significantly clarifies the constitutional limits of local government's power under the Fourth Amendment regarding restrictions on people living in public spaces. The Ninth Circuit Court held that the Fourth Amendment protects homeless individuals from the unreasonable seizure and summary destruction of their unabandoned personal property, even when left momentarily unattended on public sidewalks. The court emphasized that government seizure of property must be reasonable and cannot occur without an at least objectively reasonable belief that the property is abandoned or poses an immediate threat to public health or safety. Furthermore, immediate destruction without notice or an opportunity to reclaim the property violates constitutional protections. This ruling restricts local governments from adopting broad policies that permit the confiscation and destruction of the personal effects of unhoused individuals without due consideration of constitutional safeguards, thereby affirming homeless persons' retained possessionary interest in their effects protected by the Fourth Amendment. In summary, cities can remove abandoned property, remove belongings with advance notice, and store and move property for pickup, clear areas for public health or safety. However, they cannot treat tents or makeshift shelters as automatically unprotected, take or destroy belongings without warning, or enforce rules unequally without clear procedures. It's important to mention that state constitutions also play a key role. As Sarah K. Franklin and Lauren Riley explain in their paper, The Unavoidable Consequences of Homelessness, challenges based on the state constitutions hold significant potential because these constitutions cannot provide less protection of rights than the federal constitution. In fact, they can extend greater protections. Simply put, the federal constitution establishes a minimum baseline, not the maximum limit. Following the Johnson's decision, it's expected that more homeless rights cases will be brought up into state courts, particularly those involving protections similar to the Eighth Amendment's ban on cruel and unusual punishment. A notable early example is Kearney v. Spokane, which was filed shortly after the Johnson's decision, and it contests two Spokane city ordinances as excessively cruel under Washington state's constitutional counterpart to the Eighth Amendment. These laws criminalized camping, sitting, and lying down as misdemeanors regardless of whether shelters were available. Advocates in such case benefit from the fact that states often interpret their own constitutions more broadly than the federal one. For instance, Washington's constitution omits the federal language requiring punishments to be unusual, thereby offering stronger safeguards for unhoused individuals facing criminalization. Washington's not alone in this. Other states, including Arizona, Pennsylvania, Delaware, Rhode Island, Kentucky, and South Dakota, have similar constitutional provisions without the federal unusual punishment requirement. Many states' constitutional texts differ in meaningful ways from their federal counterparts, and numerous state courts recognize more robust protections against cruel punishment than those afforded federally. Therefore, state constitutional provisions to the Eighth Amendment continue to provide a powerful avenue for legal challenges. So now that we've established clear guidelines for the constitutional limits of power for local governments, let's analyze how governments have managed people living in public under the Constitution. 5,398 people were reported to be homeless in Portland at one point. To solve this, Portland elected Keith Wilson as their new mayor. One of his main running points was to address the homeless crisis in Portland. As reported by Portland.gov in January 2025, he presented his blueprint to end unsheltered homelessness in Portland, including setting up an incident command system to coordinate the work of government agencies and partners led by Portland Solutions, build overnight shelters that offer a safe bed for the night so that people don't have to sleep outside, open overnight shelters when need is high and close them down when need is low, open 4 new day centers, one in each of the city's 4 voting districts, with a total capacity to serve 600 guests per day. He also wanted to ensure that anyone who needed help could receive it, and that his plan required no new existing laws or ordinances, but for the police to enforce the existing ones. In his quarterly update to the Portland City Council Committee on Housing and Homelessness, as of April 24th, he has opened 3 shelters and is set to continue opening more. He has also faced challenges, such as finding that there are actually nearly 7,000 people living unsheltered in Portland metro area, more than what was originally thought. He continues to work to solve unsheltered living populations by his deadline. I had the opportunity to interview Mayor Wilson about his efforts to address homelessness while remaining within his constitutional limits. Join me in listening to the interview with Portland Mayor Keith Wilson.
There we go. My first question is, since the Supreme Court's ruling in Grant Pass v. Johnson, giving more power to local governments, how has Portland's approach to public camping been affected?
Oregon is the only state that still has camping as decriminalized. So while Grants Pass versus Johnson was upheld, or in other words, it is a jurisdiction can now enforce no camping codes. They can in all states in the 9th district except for Oregon. Oregon, I believe it was 2 or 3 years ago, passed House Bill 3115, and it codified Boise versus Martin, where we have to provide a 72-hour notice to those that are camping, and we're unable to enforce our camping codes if we're not able to provide a shelter for the person being affected. So it hasn't changed anything in Oregon whatsoever.
And how do you address homelessness while still ensuring that the city doesn't violate anyone's constitutional rights?
So currently we have and or spend about $23 million a year in camp removals. And so what we will do is we'll wait for our complaint system to take notes from concerned citizens and businesses. We'll log them, we'll prioritize those encampments, and then we'll send out an individual to assess the encampment. And if it meets a certain criteria, then we will post it, noting the person has 72 hours to vacate, and we are going to clean it up on the 73rd hour until the 14th day. So we'll send a crew in there between the 72 hours or the 14th day. That's cool. President Biden just walked by. That was pretty cool.
Oh,
I
wow.
mean, I'm in DC.
Oh, wow. Are there
Yeah.
any constitutional limits that make addressing homelessness in Portland more challenging?
Yes. I mean that one I just mentioned to you
Yeah.
definitely creates an issue.
And then how do you balance public pressures between groups and the legal and constitutional limits when you make decisions on homeless issues?
Quentin, can you repeat that, please?
All right. How do you balance public pressures with the legal and constitutional limits on what cities can do to solve homelessness?
Yeah, that's a really tough question, but a very important question. So I can tell you what Portland's going to do. As of today, the county just rescinded a rule whereby they were handing out tents. And so that's kind of the antithesis of your question is what can they do to assist or reduce encampments? Well, when they actively foster unsheltered homelessness by handing out tents, that's anathema to what we should be doing. And so today they just made that announcement. You can check the Oregonian and see it. Now, what Portland is doing is we are surging up overnight shelter, and by doing so, we'll be able to more quickly enforce our no camping codes because we'll have more shelter beds for individuals. So right at that 72 hours, our goal is to really provide access to service. So our outreach teams will walk up to an individual and say, I want to help you. What does it look like? But you can't stay here. And the good thing is that we will provide a better location than where that person is. Instead of just moving them on, we'll be able to provide life-saving care.
And do you think these rights of local governments to enforce public camping bans, do you think they should have more rights or less rights?
Well, more rights, because when you have people suffering and dying on the street, it's an intolerable state. So a government that allows that to occur messages to its citizenry that they have and are helpless, that they're not guiding themselves, and they're certainly not governing the community.
And what would success in addressing homelessness in Portland look like to you?
It would mean that any person in need has life-saving care and access to support to help them through the difficult time. So, anytime somebody is living unsheltered, it's a tragedy. It's a lost opportunity. And so, what it would look like is that the streets are clear and clean, and that any person in need, whether they're housed on the verge of becoming unhoused or unhoused and looking for life-saving care, has it. And it has, and it's available every day and every night, not in an erratic or um, not sustained way.
And finally, is there anything you want the public or anyone to know about your personal efforts or Portland's efforts and the solutions that you've started taking to address this issue?
Yeah, so we're committed to caring for all Portlanders. If you're in Portland, our job, my job as mayor, is to ensure public safety. I cannot ensure public safety if somebody's living on the street. It impacts community standards. In other words, a shopkeeper and a resident should expect that their doorway not be used as a toilet or a bedroom, but in the same respect, a houseless person should expect that they should have the basic needs of a roof, something to protect them from the elements, and life-saving care.
The mayor's responses reflect Portland's and his ongoing efforts to solve homelessness in Portland while still remaining within their constitutional limits of power. The City of Burn, Washington enacted Ordinance 818, which was later amended by Ordinance 827 to restrict individuals experiencing homelessness from living on public land within city limits, except for during designated nighttime hours, which were from 7 p.m. to 6 a.m. and only in specific areas approved or permitted by the city manager. This ordinance criminalizes acts such as sitting down personal belongings, cooking outdoors, or covering oneself with a blanket in public spaces, effectively banning homeless residents from using public land for survival during the day and only in designated areas at night. However, Buren lacks sufficient shelter capacity to accommodate all of its homeless population, particularly with single men, youth, and couples, leaving many with no lawful place to reside. Enforcement began on December 1st, 2023, with the eviction of residents from the Ambaum encampment, without adequate shelter alternatives offered and the disposal of their property. This has led to claims that the ordinance amounts to unconstitutional banishment, cruel punishment, and a violation of due process and equal protection under the Washington State Constitution and the Federal Constitution, as it penalizes homelessness itself rather than a specific harmful conduct. While both cities are attempting to address the homeless crisis while remaining within their constitutional limits of power, there are a few key fundamental differences in how local officials view the homeless crisis under the Constitution. Portland has focused on opening shelters, while Burien has passed new ordinances restricting people living in public. Furthermore, Portland has taken a more cautionary approach to not violate anyone's constitutional rights, while Burien has arguably overstepped their constitutional power at times. The constitutionality of restricting people living in public is a controversial topic that affects thousands across the country. Many homeless advocates still hold that the ruling Grant Pass v. Johnson and other key court rulings to be criminalizing poverty and are unconstitutional. However, many, including Mayor Wilson, agree that cities need more rights to restrict people living in public for safety concerns and to keep homeless people safe and to keep their streets clean. What do you think? Are the current limitations on local governments constitutional? Or will future cases need to limit the power of local governments to restrict people living in public? Thank you.